the Director of the Legal Aid Commission, colleagues, ladies and gentlemen. My paper is on institutional, cultural and legal barriers to gender justice in Fiji. We often talk about the concept of the rule of law. The rule of law is said to be about equality before the law. Not just the concept that everybody must be subject to the law, but also that everybody must be subject to the law in the same way. And so therefore, procedures and processes must apply in a uniform manner to all people who use the court system. And it's for this reason that forum shopping, for instance, for your favorite judge is not considered to be a matter which would uphold the rule of law. So then the next question is, why is it that there is such a low reporting figure for gender justice? Why is it that so many women and girls and victims of sexual abuse and domestic violence choose not to report the offences, choose not to come before the courts? In examining this question, we really have to ask ourselves about the kind of cultural values and cultural beliefs that we all grow up with. We know as we grew up that the way we walk, the way we talk, the way that we behave in society is determined by the way that we are brought up. And for girls, there are expectations of our behavior. We also know, as women and girls, that we are judged ultimately in our communities, not by the excellence of our submissions in court, but for how well we cook or we clean, what a good wife and mother we are. And so therefore, ultimately, when we come before the courts, we are judged not by whether a criminal offence has been committed, but by our social behavior, because this is how we grew up and this is how social expectations really guide the way that the courts think. So then, the low reporting figure really questions the idea of equality before the law. Because if sexual stereotypes determine whether a woman is going to report an offence at all, because her first duty is to the family, then it will lead to very low reporting figures for gender-based violence. In some countries, it is assessed that more than 80% of offences against women and girls are not reported. So at the outset then, we need to question equal access before the courts, because women and girls are choosing not to come to the courts and report at all. The next question is, for those women and girls who do report offences against them, how does the justice system treat them? Is there equality of treatment? We know that for many years, when women and girls went to complain about offences within the family to the police, that the police would put a lot of pressure on them to reconcile the matter. Because domestic violence, for instance, was seen as a private matter, the business of the family, not the business of the courts. It is for that reason that a previous police commissioner passed the no-drop policy. This policy was that police officers were not authorized to allow reconciliation at the police station. It's a commendable policy, and it has been continued by subsequent police commissioners. But it really does not answer several other difficulties about the way that women and girls are treated in courts. The first is, what happens to the reconciliations which are encouraged by the police without registering the complaint in the station diary? Secondly, what about the policies of the prosecutor? When considering whether or not there's a reasonable prospect of a conviction, which is of course a criteria for prosecutors, is the prosecutor considering whether there is no supporting evidence, that it's only a woman's word against the accused? How does the prosecutor assess the evidence? Of course, we don't really know, because that assessment is done behind closed doors in the DPP's office. But it is a place where, in fact, gender bias could operate to determine whether or not a person gets prosecuted. Next, although the Domestic Violence Act prohibits reconciliation of domestic violence, it does not prohibit weight being given to reconciliation in the sentencing process. And we know that when a perpetrator says that he's sorry and that his wife has forgiven him, and the wife speaks in court and says that she's forgiven him and that they've reconciled, that often the judicial officer puts disproportionate weight on such reconciliation. And that is without a consideration of Section 4.3 of the Sentencing and Penalties Act, which sets out how a court is to sentence in a domestic violence matter. It's interesting that although the Sentencing and Penalties Act is one which is rigorously followed by judicial officers in all other respects, there is sparse mention of Section 4.3 of the Sentencing and Penalties Act in domestic violence sentencing remarks. Recently, however, the High Court has taken a very strong leadership role in how this is going to be dealt with. We have to remember that we live in a world which is post-corroboration. If you'll recall, once we had a rule that the evidence of a woman or a girl or the survivor of sexual offences was not enough for a conviction without a warning to the court. That rule of corroboration has now been abolished, both by the Court of Appeal and by the Crimes Act. But the question is, no matter how much you abolish laws, what's actually going on in the mind of the judicial officer is something which is not subject to open scrutiny. So in the mind of a judge or a magistrate, is the rule of corroboration alive and well? Is the judge or the magistrate still asking himself or herself where the supporting evidence is and whether he or she can rely on the evidence of the victim alone? We should also remember that the law of recent complaint has not always been operating in a very fair manner. It is intended to be a scaffold. In other words, the law of recent complaint is based on the premise that if the victim has complained very quickly after the offence to someone, and that evidence is led before the court, it has the effect of strengthening the evidence of the victim. But in fact, you'll see increasingly in the courts, the question which is asked is, why didn't you complain earlier? Why didn't you tell your mother? And the effect of that line of cross-examination is that a lack of recent complaint weakens the evidence of the victim. So it's become a sword, not a scaffold. And surely is based on a gender stereotype that after a woman is raped or sexually abused or assaulted, that she will raise a hue and cry. If we already know about low reporting figures, we already know how difficult it is for women to report offences against them. Why should we be surprised that she's reporting late? So let's go back to sentencing. We know that a good plea in mitigation is one of the best things a good lawyer can do. So a lawyer will refer to the tariff, aggravating and mitigating circumstances, and will ask for a sentence which is low down in the tariff or outside of the tariff, or will lead to a suspended sentence. And the best way to try and get some sympathy for the court is to say that the perpetrator is really sorry and has made amends. But there is very sparse reference to Section 4.3 in the decisions of the courts. And despite the fact that there is no real evidence put before the court of genuine contrition, despite that, the court seemed to lean in favour of suspended sentences and non-custodial sentences simply because, for instance, the victim has asked that there be some mercy shown on the perpetrator. So in 2012, the Honourable Justice Ganda said in the case of Rolingalevu and the state that traditional apology should be looked at very carefully by the courts. In this case, the victim's mother apologized to the perpetrator on behalf of the victim, then put pressure on the victim to withdraw her complaint before the courts. And the judge said, despite the fact that she had apologized, despite the fact that she had signed a statement withdrawing her complaint, she still gave evidence. She stood alone, everyone was against her, including her mother, and she gave evidence of rape and defilement by the perpetrator. The judge said, look, we take pride in our customs and traditions, but they should never be used to restrict access before the courts and access to justice. He said, without accountability, relationships cannot be restored, no matter how much a traditional apology is offered. and he said that this was an exceptional case where customs and traditions were exploited to suppress the truth. In another case, more recently, of Nauru Sao, HAC 201 of 2018, the Honourable Justice Wimalasena looked at the UK's sentencing guidelines as to how much weight can be put on reconciliation after domestic violence. He said reconciliation after unleashing violence at home does not bear much significance in sentencing a perpetrator of a domestic violence offence. The courts have always looked at forgiveness and reconciliation in domestic violence offences with scepticism. He then looked at the UK sentencing guidelines on domestic abuse, and he said this, quoting from the UK Sentencing Council: "A sentence imposed for an offence committed within a domestic context should be determined by the seriousness of the offence, not by any expressed wishes of the victim." He said there are a number of reasons why it may be particularly important that this principle be observed within this context. Firstly, the court is sentencing on behalf of the public. Secondly, no victim is responsible for the sentence imposed. Thirdly, there is a risk that a plea for mercy made by a victim will be induced by threats made by or by fear of the offender. And lastly, the risk of such threats will be increased if it is generally believed that the severity of the sentence may be affected by the wishes of the victim. And this makes very good sense. If a perpetrator thinks that the wishes of the victim will determine whether he gets a suspended sentence or not, then consider how much pressure will then be put on the victim to make this very request to the courts. This puts an unbearable emotional, psychological, and physical burden on the victim if she believes that it's her request that will lead to the lenient sentence. Thus, the role of the courts in stepping in and making a decision not on her behalf, but on behalf of the community, the public of Fiji. A very, very important decision, and one which really shows the leadership of the High Court in cases of sentencing of domestic violence. So in conclusion, this paper indicates how insidious gender bias can be in the justice system. It can have the effect of depriving a survivor of sexual and gender-based violence of any hope of an equal justice. There are many victims of sexual and gender-based violence who have said that the court process was so traumatic for them that often they felt that they were being raped or assaulted again. They felt that they were on trial. Their social lives, their emotional lives, their social habits, their relationships and their friendships were actually on trial, when the question should have been whether the rape or the assault had really taken place. There is a need, therefore, for all criminal justice officials, including those at the bar, to really look at the way their attitudes and attitudes in relation to gender stereotypes affect the way that they do their work. Are they really helping to deliver an equal justice? Or is the system stacked against the victims of sexual and gender-based violence? These are important questions. We know that there are a large number of cases before the courts of sexual and gender-based violence, many of which are involving children. Whether this is as a result of increased offending, or whether it is as a result of increased reporting, as a result of the offense of legislation such as the Domestic Violence Act and the Child Welfare Act, we have no means of knowing. But the fact is, the increased number of cases before the courts have really put the spotlight on the justice system and justice officials to work together to really deliver an equal justice. Thank you. Vinaka Vakalev.